Hi guys, welcome to another episode of Bar Talk with Ola. This is Mojola Olua and thank you so much for stopping by. As I always say, if you haven't subscribed, please do subscribe and share the video far and wide. Today I want to talk about something very important which will provide an insight into how the criminal justice system works in Nigeria. I have titled it The A to Z of Criminal Justice in Nigeria. The A to Z of criminal justice in Nigeria. I'm going to provide, a step-by-step guide into how criminal justice is achieved or arrived at in Nigeria. Essentially, I'm going to provide an insight into how criminal litigation begins and ends. And I speak as a prosecutor, so I should know. Come along with me. So the first stage is the complaint stage. Usually a complaint is made to the police, and that's where, criminal litigation or criminal justice becomes activated. A complaint is made to the police. Now, it could be optional because the police could arrest someone on their own who they find committing an act. But usually it begins with a complaint. So the first step or the first stage is the complaint stage. Here, someone who has been wronged, who is eventually called the complainant or the nominal complainant, makes a complaint to the police about the wrong that's been committed against him or her, and the police then swing into action. That's the first stage, the complaint stage. The next stage is the arrest stage. That's where the police, acting on the complaint, arrest suspects. Now, the police have different means of arriving at a decision as to who to arrest for a crime, but usually it stems from the complaint, where the evidence or the complaint made against a particular person is substantial enough to connect them to the commission of a crime, or where the acts described by the complainant as having been committed by that person is substantial enough to nail them or tie them to a codified crime or an offense. The police will make arrests. Persons arrested by the police at this stage are called suspects. That's because they have not been convicted of any crime, so they are not criminals at this stage. They are convicts. They are called suspects. The arrest stage. The third stage is the obtaining of statements from the suspects. That's the third stage. The police will obtain the statements of all arrested persons, all suspects, and usually this is supposed to be done in the presence of their lawyers. And there are some rules, some administration of criminal justice laws of certain states that provides that this obtaining of statements have to be recorded, else the statement will be inadmissible. I know that Section 9 of the ACJL, that's the Administration of Criminal Justice, Lagos State, provides that the aside from the lawyer being present, the statement must be recorded if it's to be admissible. Now, there are different things that goes into the obtaining of statement stage. We talk about admissibility of the statements obtained. The statements are supposed to be obtained voluntarily, that is without duress. Now, even the word obtain sometimes might be very inimical to the admissibility of statements taken from suspects. So they are not technically obtained. Statements are received from suspects. Statements are made by suspects. So that's essentially what is done at that stage. And what is a statement? A statement is just a narration of a person's involvement in an alleged crime or criminal act, or it's just an explanation of their own part or their absence from the scene of crime or from the commission of the crime. So a statement is that document that a suspect or an arrested person makes, where they narrate what has happened, how they are involved. It could be that which will separate or detach or show that they are not the person who committed the offense. It could be that thing that shows that when the offense was committed, they were at a different place, and that's an alibi. An alibi is a defense in law which places an accused person contemporaneously at a different place when an offense was committed. Now, for this to be tenable, the police will investigate this alibi as soon as the accused person raises it at the police station. That's at the obtaining statement stage. And they have to be able to ascertain that this person was at a different place at the same time that offense was committed, and there are witnesses, maybe people that they were present together, who can attest to the fact that they were at that place when the offense was committed. So if that is established by the police, that alibi will hold for the accused person. So an alibi is raised at this obtaining statement stage as well. This obtaining statement stage is very crucial for a suspect, because that's where if they have not committed the offense, it's the stage where they have the opportunity, to absolve themselves technically of the commission of the crime by stating their own side of the story. And that's why it's important for their lawyer to be present, because sometimes when an accused person is stating his own side of the story, there are some technicalities that the police might exploit to link them back to that offense unwittingly, that's on their own side. So it's important for their lawyer to be present so that they do not say anything incriminating them or tying them to an offense that they have not committed. And even if they have committed the offense, so that they do not, exacerbate their own situation and, make things worse for themselves generally. So obtaining statement stage is the third stage of the criminal justice process or criminal litigation process. The fourth stage is the search and the recovery of evidence stage. So after the statements have been obtained, the police will swing into action and begin to make searches, go and visit the scene of crime, visit places that are, linked to the scene of crime, places where the accused person might have lived, might have gone to before and after the scene of crime, recover evidence. For example, in a crime of murder, the police would go and recover probably the object with which the murder was committed. Maybe machetes, maybe guns and what have you. So this is the stage where the police will recover the evidence with which they intend to tie the suspect to the crime. So search, this is also the stage where they investigate the alibi of the accused person as made at the obtaining statement stage. And after the police have successfully gathered all their evidence and, made all necessary searches and investigation, the next stage is to grant the suspects police bail. I've talked about police bail when I spoke about bail. I'll leave a link to the video on bail in the description box so that you can look at it and watch it if you haven't watched it. So the next stage is to grant them police bail, file the first information report, and call witnesses. So if the case is subject to the jurisdiction of the magistrate court, they will be tried there. But if the magistrate court decides that it's without their jurisdiction, the accused persons will be remanded by the magistrate, in a correctional facility, and the case file will be duplicated and forwarded to the DPP, that's the Director of Public Prosecution, for his advice. Which brings me to the next stage, that's the forwarding of the duplicate case file to the Director of Public Prosecutions. At this office, the Office of the Director of Public Prosecutions, they look at the evidence in the case file, and then they look at the applicable laws, and they decide if the accused person should be charged or not. So if they decide that the accused person should be charged, the accused persons are charged, and they file an information at the High Court. They file an information at the High Court. At the Magistrate Court, it's more appropriately called a charge, but at the High Court, it's called an information. The next stage is called arraignment. I have done an extensive video on arraignment. I'm going to leave a link to it as well in the description box. Please watch it. This is the point where the accused person, comes before the judge of the High Court and he takes his plea, that's guilty or not guilty. It's essentially how, the matter is commenced at the High Court. After arraignment, the next stage is the examination stage. At this stage, the prosecutor calls his witnesses and examines them, and then the defense, the accused person's side. Now we don't call them accused persons again in Nigeria, we call them defendants. So at this stage, the defendants, through their defense counsel or lawyer, we have the opportunity to cross-examine the prosecution's witnesses As well, they will also have the opportunity to, call their own witnesses, and the prosecution will have the opportunity to cross-examine their own witnesses. So the examination stage contains, 3 stages. That's examination, cross-examination, and re-examination. So it just means that I call a witness now, I ask him questions, the other side asks him their questions, and then if I have further questions to clarify whatever he has said during this last stage, I also ask him further questions. So that's it. Examination, cross-examination, re-examination, and that's the examination stage. The next stage is the address stage. This is the point where the prosecutor will file and adopt their written address. A written address is like a summation of the case. After examination, both sides will agree on a date, or the court will give them a date to come and adopt their written address, which must have been filed earlier. So a written address is a document wherein each side will have the opportunity to make a case for themselves, referring to the evidence that's been given during the examination stage, and urge the court to decide in their favor, also citing decided cases and laws and what have you in support of their case. So usually it used to be done orally, but now, and for a long time it's now done in writing. So both sides would reduce their address to writing and file it ahead of time, and of course they would exchange it. That is, you serve the other side, you serve the other side, and then on the date that's been given or agreed to before the court, you come and adopt your written address before the court. I have made a video on adopting a written address as well. I'll leave a link to it in the description box. It feels like I've done a lot of videos on the criminal litigation process, or the criminal justice process, so I'm just going to leave a link to all the videos I've done so far on that in the description box. So after the adoption of written address, the court will give a date for judgment. So judgment is a constitutional matter in Nigeria. According to the constitution, judgment must be delivered in a matter within 90 days. Within 90 days from the date of the adoption of the written address. So it's a constitutional matter. It goes to the root of the case, and it could render the case a nullity upon appeal. So judgment is the next stage. At the judgment stage, that's where we have the conviction, the allocutors, and then the sentencing. Those 3: conviction, allocutors, and sentencing. And then after that, the accused person is sentenced, and he could either take the sentence and go to jail and serve his term, or appeal. The last stage is the appeal stage. That is, if the accused person or his counsel decides to disagree with the judgment, they have the opportunity to appeal the judgment within a specified period of time. And that's the entire criminal litigation process or criminal justice process in Nigeria. So if you have any questions about this, leave them for me in the comment section, or send me a mail at houseoflivingstones@gmail.com. I would love to hear from you. And please, can I appeal to you to please like the video? Please give the video a thumbs up if you like what you've watched, and if you've benefited in any way, let me know by leaving me a comment in the comment section. That's all I have for you today. That's the entire criminal justice process in Nigeria. I will always see you in my very next video. Toodles!